alive in 2 of his terms. This is a 1983 action, as the court knows from the briefs, and Mr. Holland maintains that on January 30, 2017, members of the Cheatham County Sheriff's Department shot him multiple times, seriously wounding him in violation of his constitutional rights. He was illegally seized under the 4th Amendment, and the actions of the appellees were objectively unreasonable. And as violators, the appellees are not entitled to a finding of qualified immunity. I think in considering whether the officer's actions were objectively reasonable in the case of Graham v. Connor, which was a Supreme Court case, the U.S. Supreme Court set out certain factors that I think were important to consider whether an officer acted objectively reasonably, including the severity of the crime at issue, whether the suspect posed a immediate threat, whether he actively resisted arrest or attempting to evade or flight. The first and third factors I don't believe apply at all. Charles Holland was not suspected of committing any crime, and he was shot when he was shot, and he was not evading arrest. The only Graham factor that possibly could work in this case would be he posed an immediate threat to the safety of the officers, but he was not a suspect. To the extent the factors applies, there are sufficient questions of fact, and that's where this case really falls in, about the disputed facts in the case that go for multiple disputes. If the suspect threatens the officers with a weapon, there is probable cause to believe a crime involving the infliction or threatened infliction of serious physical harm. And if we're feasible, some warning has been given. I think that is so important. It's not just the infliction or the threat of infliction, it's if, where feasible, some warnings has been given. And that's one of the real factors in this case, frankly, about the claim that we gave.
Now, you say where feasible. Didn't some officers yell at him and say, "Stop"?
No, sir. Did not. And I'll share that with the court in just a moment. Yeah, thank you for that. That's exactly the point I was making. In the case of Garner, which is somewhat of a seminal case, interestingly, a suspect who had broken into a house at night, the court ruled that such an action did not automatically make him dangerous. Mr. Holland contends the officers never gave verbal warnings before shooting him, and that it was absolutely feasible for them to do so. The officers contend they did issue verbal warnings, and that's what I'm going to get to in just a moment. In the course of this litigation, depositions were taken, and they're in your files, in this record that I filed with the brief, and they were taken in October of 21. Lieutenant Walter Bammon, he was asked certain questions, and if I need to cite the page and number, I will, but they're in the brief. But at page 9, line 10, we all started yelling, "Stop, drop the gun, the weapon, get down." Subject kept running. The question came next to Lieutenant Bammon was, now the reason you would have done that is because that's what it calls for, doesn't it, in your training? 919, answer, yes, sir. So not only does your statement, the question was asked, say, you said several times, "Stop, drop the weapon, get down." Subject kept running towards the tree. And I said, "Do you stick with that today?" And he said, "Yes, sir." Worth noting, and maybe not as important in the whole scheme of things, but I sent out a set of interrogatories that Lieutenant Bauman's signature was on, showing he had answered and I asked him about those. And specifically, he said, "No, sir, this is the first time I've been sworn on this. Today is the first day I've ever seen these interrogatories." I was a little disappointed in thinking there were 2 sets of lawyers. One set had started the case, and then another law firm picked it up, the appellee's lawyers today.
Excuse me for interrupting, counsel.
Sir?
Were there both audio and video?
Yes, sir.
Accounts.
And that's what we're going the appellees ask you to review it, and I certainly want that to happen, to review that videos. And I'll get to even more prevalent matters with respect to those videos of what you can hear in a matter of seconds. And then Deputy Ivy testified, the only thing I remember saying, giving him commands, was after we fired. That's in his deposition as well in the record. Though you cannot hear the recording of any verbal warnings, and I assure the court you can't, the officers' claim they gave, it can be clearly heard, clearly, Deputy Ivy yelling, "Shoot him," immediately before the three officers fired on Mr. Holland. You can hear it without any question, but nothing else of all these warnings. It just defies logic to think that we can hear that clearly, "Shoot him," but nothing else in that. To further illustrate the recklessness of these officers, and again, I don't have any personal animosity against them, I mean that. These men on the line of duty, and it's tough to sometimes fault them, but I do in this case. But to further illustrate this recklessness, after "shoot him" and the firing started, the videos will clearly show that Mr. Holland left his home to the left. There was a van parked out in front of it with one of the women who had been on the road earlier in a domestic rolling, and I put the facts of that in there, but that was a bizarre day for Mr. Holland, as you probably read, where he had an incident where two thugs, drug traffickers, came through and down his driveway being chased by police officers earlier that day into a creek where they wrecked, and one escaped, and he was well aware of that when he talked to the officers about it. And then this incident that happened out on the road in front of his house where he went out to see what was going on, and somebody hollering, "He's trying to kill me," and he's talking to a woman who happened to be Miss Puckett, who lived in the next house, by the way, in the next neighborhood, next door. As he was talking to her, this fellow who was trying to get to his girlfriend, as it turned out, Carla Kellum, almost ran over him. He had to dive into a ditch. So he asked her, Miss Puckett, to drive the van up into the driveway, and he went in the house, had his sons call, two young boys, call 911. As it turned out, Miss Puckett did, and she did. And in the meantime, the Jeep owned by this Carla Kellum pulled into the driveway. He sees it. Now he's exiting his house. As he exits house, he comes down to the van and then turns directly right to cross his yard to a big tree way out in the yard. Again, getting back to the recklessness, when the officer said, "Shoot him," one of the officers was behind the Jeep, was beside the Jeep, shot through the passenger window, and there were numerous bullets that went into the house to the right. My man's over here, Mr. Holland. The house is here. They fire away. This is clearly audible on the video. Now, in the trial judge's ruling on the summary judgment motion, the trial court acknowledged that after, and this is block letters for me, multiple reviews of the video, he was unable to detect any warnings given to Mr. Holland before the shooting. Furthermore, the investigation by the TBI who came into the investigation also reviewed very carefully, and they have enhancement qualities in their facilities, found no warnings were given. Defendants don't claim it was impractical for them to give warnings. To the contrary, they claim they gave warnings. That's what was surprising, because in the motion for summary judgment, adversary counsel argued it was a split-second decision. Therefore, it doesn't matter if warnings were given or not. They didn't have time. You'll see that they had ample time. For example, when Miss Kellum pulled up into that driveway, right behind her later, just shortly thereafter, came Deputy Royal, right behind her. He gets out, you see him walk around, and then they scurry back to the back of the Jeep, and then right then, Lieutenant Bammett has already shown up. He's out of the car, and then within seconds, Deputy Paul Ivy shows up, and as he gets out of the car, you hear in the audio, "Does he have a gun?" He's talking to Paul Ivy, beg your pardon, Royal, and he says, "Yes, he's got it." The young woman says, "Yes, he's got a gun." And then within 5 seconds, when you see the video, you can track it from 6:53 right on down, shoot him, just like that. And the firing started, including bullets that went into the house, bullets that went through the car. The case law in this case, in my opinion, is clear that law enforcement officers are not required to wait until the armed suspect actually points a gun. Now, this is what the trial judge was ruling on. He's citing Thurman versus Hawkins. It was an unreported case in the district court, I think, out of Kentucky. But he left out the most key, important feature of that decision, and that was simply in the Hawkins case. He didn't tell the rest of it where the court ruled at least where orders to drop the weapon have gone unheeded. Now, the cases that the appellees cite are cases that frankly help me, because in each of those cases they cite, and I don't want to go over them all, you've seen it or read them, I'm sure, as I've learned about, and being up here all the time, you judges always take the time to go through it. It's clear that these warnings were not given, not even attempted to be given, and the cases they cite, though, are just the opposite. In these, and I'll touch on just briefly in a moment, clearly show that the warnings went unheeded. They had witnesses. In one case, they cited the wife of the man who was shot and made a 1983 claim. The wife says, no, they gave warnings, and he approached them with a gun. Within one case of their citing, 2 feet, 10 to 2 feet, he was there with a gun. Another had information that the man who was there, a young boy, I think it was now, that was 15 years old in his own bedroom, was killed. Officers in one of those cases actually saw through the window the man sitting, later the victim, sitting on a chair with a rifle. They hollered at him multiple times, come in, because he was suicidal or had some mental issues. He's got a gun, Paul, and within 5 seconds, Deputy Ivey says, shoot him. And I mean, it's so clear you can hear it without any, and you can also hear he's got a gun, Paul, talking to a deputy, not to Mr. Holland. Merely possessing a weapon, by the way, according to the cases I cited, do not justify necessarily force. The reasonableness of an officer asserted, if he's asserting fear, will often turn on whether an armed suspect pointed a weapon at another person or these officers. That didn't happen. And it's admitted in the depositions by the officers, no, he never pointed a gun. In this case, notwithstanding the officers were trained, according to their sheriff, whose deposition was taken, Sheriff Breedlove, to de-escalate cases like this, they failed to give the commands. The defense in this case began with the officers claiming that they gave warnings and screaming warnings, loud warnings. But yet, you can't hear it, but you can hear clearly, shoot him. And there was the rule is under the Fourth Amendment that once the apprehension goes with a weapon firing, the victim or the man who's been shot, there is a seizure. And now the question becomes, was that objectively reasonable to shoot him in those circumstances that we believe are factually in dispute, and that a jury should give this man the right, Mr. Holland, to be heard on these issues.
Is the essence of your argument that this was a summary judgment decision and that there are material facts in dispute? Is that the basis of your argument?
Yes, sir. And just what I read a moment ago with the depositions. And
all right. Well, your time is up. We'll hear from you further on rebuttal.
Excuse me.
Certainly. Not a problem. Good afternoon.
Good afternoon, Your Honors. Good to be here again. Jeff Goodson of the Montgomery County Bar, here for the appellees, the individual officers in question. We would ask, the appellees would, that this court affirm the trial court's entry of summary judgment and specifically find that the use of force under the totality of the circumstances was objectively reasonable and therefore no constitutional violation occurred. There was some talk there at the end of counsel's closing remarks about disputes of fact, and the court inquired about whether there were disputes of fact. Considering that's a serious accusation in the realm of a summary judgment review, I'd like to pick up there if I may. First of all, these officers did not fire upon Charles Holland merely because he had a gun. I heard that comment too, and it's really a theme of the brief. They fired upon him because under the Sixth Circuit directive and the controlling law, there were quote unquote additional indicia that the safety of these officers and a private citizen, unarmed, Ms. Kellum, was at risk. Back to undisputed material facts. Well, what were those additional indicia beyond just holding a weapon? They are plentiful. It's undisputed. Number one, these officers were not responding to a vandalism call. They weren't responding to a noise ordinance violation call. They were responding to a domestic violence call, and each one of them knew this when they so responded. It's termed a rolling domestic assault call because there were two vehicles involved, romantic partners arguing and chasing each other down the road, right? So it's a rolling domestic call, not just any call. And as this court well knows, those domestic calls, domestic assault calls, can be some of the most dangerous that law enforcement officers are involved in. Tempers are high and flaring. The parties involved are quite often emotionally volatile. So that's important to note as a material fact, the type of call. Number two, and again, I'm talking about the additional indicia of a threat beyond just holding a weapon, and the material facts that are undisputed that make out those indicia. Mr. Holland was holding this rifle, an assault rifle, more on that in a minute because that's important under a separate inquiry under the Sixth Circuit controlling law. But he was holding this assault rifle in a low, ready position. Now, he's an ex-Marine. He was wearing camouflage. He was ready to do battle and come out and meet somebody, he said in his deposition. So he's actively engaging purposefully with law enforcement officers, but with an assault rifle in a low, ready position. Now, in his brief, he's trying to kind of backtrack and do damage control from that description of low, ready position. And he would have the court believe that there's some sort of a dispute about how he was holding the weapon and that it was really being held in no dangerous sort of a position at all. He really paints the picture of holding it vertically like this pin with the muzzle at the ground. Well, that's not what he said under oath in his deposition. Mr. Holland testified that by low ready position, and he agreed, yes, I had that weapon in a low ready position. And he said by using that term, I was holding that gun across my chest, diagonally. He said right hand, he said with the finger, quote unquote, just off the trigger, and with the left hand near the barrel, left hand on the stock. And he was asked the question specifically, now, were you ready to fire that weapon at a moment's notice, to fire it rapidly? He said, correct. So this notion that there's some sort of a dispute about how he was holding the weapon or whether he was holding it in a threatening way or in a way that the officers should have perceived as a threat, well, there is no dispute there. He was holding it at an angle, maybe closer to being pointing the muzzle at the ground than up in the sky, but he was holding it in a military fashion, in a ready-to-use fashion, ready to use at a notice, as he so admitted in his deposition. Now, more about the additional indicia of a threat and the facts that are undisputed. He testified he was moving hastily to the officer's left. He said, I wasn't slow walking, is how he put it in his deposition. He was moving hastily to the officer's left, and the officers perceived that to be a flanking trajectory. Now, this court, and any court reviewing this type of a use of force claim, must review the facts not from Mr. Holland's perspective, but from the perspective of a reasonable officer on the scene, and avoiding 20/20 hindsight perspective. And these officers, and any reasonable officer would have done this, perceived that movement to their immediate left and to Miss Kellum, the unarmed citizen's immediate left, as a flanking type trajectory. This isn't news that's just come up on appeal. This is the position they took when they were immediately interviewed by the TBI. The TBI investigator's report is in the record, and he used the expression flanking after interviewing them and getting their story on how they perceived these events. Then during their depositions, each officer was asked about this flanking terminology that the TBI investigator had used after speaking with them. And each officer agreed that's a correct description of how they viewed it. Deputy Ivy, we've heard some discussion about him. He was the last officer to arrive at the scene. Deputy Ivy testified that as soon as he saw Mr. Holland crossing to the officer's left with the gun, he immediately thought of it as a purposeful, he said, tactical position, trying to get behind a tree and trying to take a tactical position against the officers. So the record, it's undisputed as to how these particular officers perceived what Mr. Holland was doing. And back to the perspective, though, of any reasonable officer. They took it the same way any reasonable officer would have.
Excuse me for interrupting,
Yes,
counsel.
Judge.
Were there any factual disputes with reference to whether any commands were given?
Well, first of all, good question, and I've got quite a bit to say about the commands, but even if there had been, it would be irrelevant because the Sixth Circuit case law simply does not require commands. When it's a split-second, harrowing situation like this where there's already an immediate threat of safety to the officers or to others under the Graham case. That's that second factor counsel alluded to. And when it's a split-second, rapidly developing situation where that threat's already been established, a command requirement under the law, well, that command might be the last one that the officer ever gives. And that's coming straight from the case law. So in the Sixth Circuit...
Well, if you don't mind, would you answer his question? You said you said it was irrelevant, but
I'm sorry, Judge.
We would like an answer.
There's not a reasonable dispute that any reasonable juror would recognize. There are a number of spots in the record that demonstrate commands were given. Number one, Deputy Thomas Royal testified. He said it's faint. It's not a model of audio clarity, but the dash cam video shows. He said, I said a command similar to the command, let me see your hands or show me your hands, twice. And when you review the video, yes, that footage is there. And on a summary judgment motion, you take the facts as you find them on the video if there's a video. And there is no dispute, not a reasonable one, that a juror would recognize concerning whether commands were given. Additionally, Deputy Ivy testified that when he arrived at the scene and just began to run down the driveway, that he heard Lieutenant Bamman and Thomas Royal, Deputy Royal, the other two officers, yelling, he said, screaming at Mr. Holland, screaming commands at Mr. Holland. The video does in fact show that as well. Not models of audio clarity. This wasn't a Music Row studio.
The video shows...
The dash cam video, which contains audio.
Yeah, I'm not sure I understand. You say the video shows them yelling, but the audio doesn't? I don't understand that.
No, the audio is there, Judge. I'm sorry if I'm being confusing. It's a dash cam video, and it has audio footage on it, and you can hear the screaming commands. You can hear two commands. It's faint, as Thomas Royal correctly testified. It's faint. It's not in a recording studio. It's in a crazy situation in the front yard at night, and he was not wearing his lapel mic.
Are you talking about another video than what Mr. Fraley was talking about?
Surprisingly, no. And I've heard these commands on the video. You can hear the screaming going on. They weren't required to give commands under the law, but in the couple of seconds they had to give them, they did give them. Deputy or Lieutenant Bamman testified that he was screaming so many commands that he lost his voice. Again, Thomas Royal testified, Deputy Royal testified that he said, "Let me see your hands, let me see your hands," or words to that effect, or "show me your hands," twice. And the video does bear that out. You might have to turn it up, you might have to use headphones. Again, it's not the audio that's part of the video. Dash cam footage is not a model of audio clarity, but the commands were given. So I don't think, Your Honor, to answer the question, and forgive me, I didn't mean to sidestep it, there's not any reasonable dispute about whether commands were given. And I heard Your Honor, I think a moment ago, ask at the very beginning of counsel's comments, wasn't there a command to stop given? Yes, and that too can be heard on the video. On the audio that's attached to, if you will, the dash cam video, you can hear a loud command, "Hey, stop!" It's fleeting, it's quick. This was the 5-second encounter from the moment Mr. Holland began his advance to the moment the command shoot was given. And again, because of that, the fast-paced nature of this incident, because of the holding of the rifle and the other additional indicia of the threat that I mentioned, there is no requirement in the Sixth Circuit under the controlling law that commands be given. Because in this type of a scenario, if you require a command, again, it could be the officer's last command. But I don't think there's any reasonable dispute about the commands, but again, they weren't required. That's really the most important issue to note here, is that commands weren't required. Yes, they gave them because that's remarkable. It's commendable. They did a fantastic job in handling this circumstance, but they weren't required to yell, "Hey, stop," under the totality of the circumstances, or drop the gun, or any other sort of a command. I would also note, it's in our brief, there is authority also for the proposition that when you have armed or uniformed law enforcement officers, so they're in uniform, in marked vehicles, with overhead lights on, which they did, then that is already sufficient warning of two things. And I believe this is at page 58 or 59 of our brief. One, of law enforcement presence on the property, and two, that lethal force might be used. We've cited at least 2 cases for that proposition. But again, under the Sixth Circuit controlling law, no warning was required. Of course, I've touched on this. I'm kind of circling back to the additional indications that there was an immediate threat. Again, an unarmed civilian, Miss Kellum, was in the middle of all of this split-second encounter and certainly could have been killed. There are also 3 important inquiries that the Sixth Circuit tells us to ask where you have a plaintiff or a suspect asserting that, well, I just had a gun, I was just shot because I had a gun or a weapon. And those 3 important inquiries are, where was the weapon? What type of weapon was it? And what was happening with the weapon specifically at the time? We've touched on most of that already, but that's Sixth Circuit case law, Thomas versus City of Columbus, and we can answer those questions really quickly. Undisputed material facts are the basis for these answers. Where was the weapon located? Firmly in Mr. Holland's hands. What type of weapon was it? Not a knife, not a baseball bat, not a slingshot, not even a .357 Magnum. But other than a bazooka, perhaps the most powerful and deadly weapon he could have had in his hands, an AR-15 assault rifle. It has a range, by the way, of 500 to 600 yards. A whole lot different than a case where a knife-wielding assailant is approaching an officer from 10 feet. Well, this is a deadly weapon from a long, long range, and as the trial judge correctly noted, it's a high-powered rifle. It can explode a human skull. It can totally destroy body parts. And there's a reason why Deputy Bamman, he's to be commended for this under such pressure. Lieutenant Bamman, he turned to Deputy Ivy immediately upon Deputy Ivy's entrance to the property, and he said, "He's got a gun, Paul. Looks like a rifle." He did that because that's a game changer in many respects. he was sending a quick message there under those awful circumstances that we may have this individual outmanned, but he's got us outgunned. My time is just about up. I would respectfully say this. If there's anyone who acted unreasonably on that evening, it wasn't my clients. Respectfully, it was Mr. Holland. He left the safety of his home and his family with a 9mm pistol on his hip and a Colt AR-15 in a low-ready position, loaded in his hands, and a tactical sling tethering it to his body, wearing camouflage, and went out to facilitate and get involved with a direct engagement with law enforcement officers, whose presence was clearly plastered about the place with lights, uniforms, their vehicles, etc. And I would ask that this honorable court affirm the lower court's finding that the excessive force claim should have been dismissed for lack of any constitutional violation.
All right, thank you, Mr. Goodson.
Thank you.
As a Marine myself for 14 years, we are trained that you put it in the ready position as opposed to here. There's no question about that. I think even police officers now are trained to that.
Can you explain why Mr. Goodson says you can clearly hear these warnings on the tape?
You cannot.
And you can't?
I dispute that. That's the material fact. I dispute it with vehemence. Furthermore, he said that that Ivy was already there. He was not. The first car was the Jeep, Carla Kellum. Behind her was Royal. Lieutenant Bama came up immediately. Before, just as Ivy's pulling into the street, you hear, he's got a gun, Paul. This is Ivy, beg your pardon, Royal, who's with Carlum, with talking to her, and she says he's got a gun, and then within 5 seconds of, get the right ones, Ivy getting out of his vehicle and approaching, the next thing you hear is shoot him. Now you hear what I just said, he's got a gun, Paul, but in the testimony you'll read in the deposition, they were screaming and hollering. There's no reason why that wouldn't be picked up if you hear clearly the other. They're saying, oh, he should have known. He came out of the house before the police arrived, when the Jeep came up, and was coming when one of the officers pulled in, that was Thomas Royal, and began to go across. Initially, they said in their deposition he was running. Then they all calmed down and said he was moving hastily. All they had to do was say, this is the police. One of the officers, as it turned out, knew my man.
Why do you have to say this is the police if you're in marked police cars and the emergency lights are flashing? I don't think I would need the oral declaration.
Well, you're right about that if you saw it, but he didn't. Because if you look at the video, the lights have a particular ability to be flashing to the back or to the front. If you'll look, it's in the back. But when he sees, the first thing is the Carla's car, and he sees that, her lights are on, and he's moving across like this. And as he moves across, all they had to say, they call it a split second. It was a split second when they shot him without the first warning. And that's the disputed fact that I believe that a jury should be able to hear, and the summary judgment should be overturned.
All right. Thank you, Mr. Fraley. And Mr. Goodson, for your arguments, we'll take this matter under advisement. That concludes the docket.
Good to see you.